Now let's talk about the amendment. We're going to talk about works published between January 1st, 1978 and February 28th, 1989. In 1978, which was the actual effective date of the 1976 Copyright Act, several things changed. Subject matter now included published and unpublished works, not just those that were being published. Copyright began as soon as the work was fixed in a tangible form. So if a book written in 1991, that's when the copyright begins. Copyright protection begins. The notice on the publication, however, still was required. If you're going to publish your work, you still had to put notice on it. The Act also defined what was publication. Publication is distribution of copies or phonorecords of a work to the public by sale or other transfer of ownership or by rental, lease, or lending. These are all publication. The offering to distribute copies or phonorecords to a group of persons for purposes of further distribution, public performance, or public display constitutes publication. So in the first one, we have this is our owner author doing the actual distribution or publication. The second one, the offering to distribute, we're talking about like a publisher. Number 3, a public performance or display of a work does not itself constitute publication. So we're going back to this performance or with the display. The same definitions from our last discussion apply. So a public performance or display of a work does not itself constitute publication. And you remember, if it's displayed, the owner has to take steps to ensure that there's notice with regards to copyright. And for public performance, a public performance does not constitute publication. Also, the consequence of omitted or defective notice was actually less severe. It doesn't invalidate the copyright outright. What it does is, if omitted from a relatively small number of copies distributed to the public, and the work was registered no later than 5 years after publication, and a reasonable effort was made to put the notice on, it's going to be okay. You're not going to lose the copyright. The owner isn't going to lose the copyright. Notice was omitted by a licensee in violation of an express written requirement in a license agreement. That's our same one where the publisher fails to put it on, or there's a contract where they're required to. Not going to lose the copyright. So what happens after March 1st, 1989? Congress did away with the notice requirement. The reason is that, I said it earlier, we're inconsistent with the leading international copyright treaty, the Berne Convention. And basically it provided that the enjoyment and the exercise of copyright shall not be subject to any formality. Statute says authors may use notice. I like the word may, right? It strongly suggests that you should, and most do nowadays. You don't see anything that doesn't have a copyright notice on it. Remember our reasons and purposes from copyright from way back at the beginning, from the introduction to intellectual property discussion. U.S. laws pre-1989 were seen as an incentive to authors to create, encourage them to produce works, and when they do, are entitled to claim exclusive rights in their works. If copyrights are an incentive to produce, then requiring authors to meet formalities helps limit copyright to those authors who really had copyright in mind when creating the work. By contrast, the Berne Convention seems as representing the view that copyright is a moral right. An author, as the creator of the work, has a natural entitlement to control uses of the work. Such natural rights should not be conditioned on complying with legal formalities. And that's actually what the gist is worldwide, is that view, the Berne Convention view. Because of the formalities in the U.S., as I mentioned, foreign works were generally not protected under U.S. law, which meant that U.S. publishers could freely publish the works for foreign authors free and clear. However, that has changed. I don't know why my slides are doing funky things. They weren't like this before. Sorry about how it gets cut off. Restoration of lost copyrights for foreign authors. We have a amendment to the statute that becomes effective January 1st, 1996. Oh, that same year we have the case involving the Lord of the Rings. Many foreign authors have lost their U.S. copyrights due to the failure to comply with the requirements of the U.S. formalities. While on the other hand, U.S. authors rarely lost their rights in other countries because there wasn't this requirement for formalities. As intellectual property became part of international trade negotiations, the U.S. agreed to restore some of the foreign copyrights due to the failure to comply with the formalities requirement. And they passed legislation, which, like I said, came into effect January 1st, 1996, that the foreign copyrights were restored if they had to meet some conditions. The work was first published in an eligible country, meaning the country was a member of the Berne Convention and the World Intellectual Property Organization. The WIPO is what you might see it broken down. And they had to be at least 30 days before the U.S. publication. The work cannot be in the public domain in the original country due to expiration, so you can't gain U.S. copyright protection if you don't have it in your own country. The work is in the public domain in the U.S. due to the failure to meet formalities requirements, so nothing else. Or it could be due to the lack of protection before the 1972 sound recordings, or due to the lack of national eligibility. The most common one is the first one. The work is in the public domain in the U.S. due to the failure to meet formalities requirements. Those are generally the ones that the cases have come under. That's the one we'll focus on. And the author was a national of an eligible country. So not only a member, the country has to be a member of the Berne Convention, but the author has to be a national of that country that they're claiming is the eligible country. And if they meet those, what do they get? What do they get if a foreign author meets those requirements? The foreign copyright holder is entitled to the remainder of the term that the copyright would have had but for the loss of protection. They don't get a brand new copyright. It just picks up where it should have been had they got it in the first place. And this restoration is not automatic. Restoration is automatic. They don't need to file anything, so they have rights right away. They have the rights against infringers right from the date of the restoration. So as soon as this law came into effect, if they've met the requirements, which they would have to show in a case if they were sued, like in the case we're going to be talking about, that they fell into this category. They don't have to go and file an application saying, oh, look, I meet it. Give me a copyright. So what happens if you used a work that was in the public domain and now it is restored? What do you think? If you infringe upon the work while it was in the public domain, there's no recourse. If it was in the public domain at the time you used it and now it's restored, nothing can happen. What if you still have copies? What if you are still using it, or you're making a derivative, or you had made a derivative? Maybe you made a movie of this Lord of the Rings book, Volume 1, that was in the public domain. Maybe you still had printed copies. What do? You got to throw them out? Well, what you have to do is there's a grace period for 1 year to sell the works you have. So if it was copies of a book, made extra copies, and now it's back into the public now that it's back under copyright protection out of the public domain, you have 1 year to sell off what you have, and you cannot make any new ones, not without permission anyway. So far we have, if the act happened before the restoration, while the work was in the public domain, nothing can happen. Nothing can happen. You were free to use it and make the money that you made off of it. If now it's back in under copyright protection, there's a 1 year grace period to sell the work you have. Can't make any new ones. But if it's derivative, say you made a movie, you can't show it or do anything with it now unless you have permission, or you have to pay now the copyright owner. So you either have to destroy it or get permission to use it. What if you're ready to launch something that has, it's a derivative work, and you haven't even put it out? Same rule applies. You have to get permission. Otherwise it's just lost work. Well, the folks who were using Lord of the Rings right before the movie trilogy rolled out, and Congress passed this Restoration Act, and now it came out, Lord of the Rings and many other things came out of the public domain and now are under copyright protection. There was a lawsuit. Lawsuit was filed as to whether or not it was constitutional for Congress to make a law that takes a work out of the public domain once it entered. And this was the case that involved the work of the Lord of the Rings. And the question was the constitutional issue of whether Congress can, consistent with the copyright clause of the Constitution and the First Amendment of the Constitution, remove works from the public domain by restoring copyrighted works that had either expired or failed to vest due to a failure to comply with technical requirements under the Act. And the Supreme Court said, yes, that was constitutional, that it was within the statute. It was within the bounds of the copyright clause, I should call it a clause, the copyright clause of the Constitution, and it was not a violation of anyone who was trying to use it, First Amendment rights, i.e. they were claiming they created a new work and then wanted to put it out, but then could not. So it was a violation of the claim was that it was a violation of their constitutional rights. That was not the case. And I will make a note to say that the justice who wrote the majority opinion was Ruth Bader Ginsburg. And I believe it was all of the justices who agreed with that decision and signed on to the majority. So that is how the Lord of the Rings was returned to copyright protection. Move on to registration. The U.S. has a copyright office for registration and depositing your work. You don't have to register your work. Your work has copyright protection upon putting it in a fixed tangible medium. But registration has practical advantages, right? Even if it's not required anymore. What can you think of would be an advantage? And you could do it any time, by the way. You can, I didn't register my work that I created 2 years ago. You can still go and register it. But when you think about an action for infringement of a copyright, right, in a U.S. work, number one, you show that you've had its nice documentation that shows when you created it, or at least when you registered it, so you have some sort of date. Also, there was let me give you the three my three reasons here. Well, if you want certain damages, the Act actually says, here are some damages that we will give you that are under the statute if you meet infringement. Registration also creates a public record. But there was a recent case recent, March 2019, I think it was. March 2019. Yep, March 2019. That said, and it was a Supreme Court case that said if you want to sue for copyright infringement, you must register your work. And if you don't, then you cannot sue for infringement under the Federal Copyright Act. So in March 2019, our Supreme Court said in order to bring an infringement case under the Federal Copyright Act, you must register your work. Now, you don't have to register your work, not required to, but if somebody infringes on your work, it has to be registered before you can bring a lawsuit. You have to hustle down to the U.S. Copyright Office and get it registered before you can file a lawsuit. And in April of 2020, we had our first case on this particular issue. That was in the First Circuit Federal Court. And that court ruled, and in that case, somebody filed their lawsuit first and then went and registered their for their copyright. And the case was subject to dismissal for failing to have it registered beforehand. But what the court said was, you know what, you can just amend your complaint that you filed with the court. It stayed, so we have the dates. Basically, it was just a little formality, basically stating that you can fix your complaint now that you're registered, but you couldn't have filed for your case first. So that is certainly unique. So now, in order to bring a lawsuit under the Federal Copyright Act, you have to do so. You'd have to file before or register before you actually have any cases. So what's the advantage of registration? Well, if you want to sue somebody, by all means, you need to get it registered. And like I said, it creates a public record. Registration requires filing an application, paying a fee, meeting the depository requirements, which we'll get to in a second. Actually, I'll tell you what they are now, because it's going to be my next slide. Meeting the depository requirements, which are 2 copies of the best editions of published works, 1 copy for an unpublished work, and works published outside the U.S. only need 1 copy. So 2 applies to U.S. works, and I'll mention it again in a little while. I have always told folks before this requirement of registration, being registered, having to be registered before bringing a lawsuit, I've always told people just mail yourself a copy, right? Then you don't open it up. You have the postage date stamped, so you can show a date. A lot of folks have suggested that. Anyway, so registration doesn't take all that long. It's an application fee. It's an application with a fee and sending in 2 copies. It's not really that hard, so I would recommend registering any works you create. Let's move on to renewal. I'm just going to give a snapshot right here, but we are going to cover it more in duration, which is our next topic. But works published before 1960, because it is a formality, I want to mention it. Works published before 1964 went into the public domain if there was not an application made for the 28-year renewal. In 1976, the 1976 Act, changes were made to the renewal of copyrights. Works published before 1978 received an additional 19-year renewal. And in 1992, it was automatic. There was an automatic renewal for works published after 1963. And in 1998, another extension was made. I am not going to hold you. We'll talk about renewal in a little bit more detail, but I'm not holding you to all these different dates and different changes and doing math calculations. You need to know that depending on what section of the act we're talking about was whether or not a renewal period existed, because that still comes into play. And I'm going to talk more about it when we talk about duration, because that's really when renewal messes things up. But I am going to note works before, this is key. If you see a work that's before 1964, now this is a hard fast rule. This isn't, oh, maybe this, maybe that. This is a black and white rule right here. Works before 1964, two things. Was there a proper copyright notice? Two, was there a proper renewal for a 28-year extension? If there's failure to either one of these, the work's in the public domain. Okay, if there was no copyright notice when it was published in 1964, it's gone. And was there proper renewal for a 28-year extension? So after 28 years from 1964, if there wasn't an application for a renewal, it's now in the public domain. Consider that if you're using any sort of work. But when I say there's no protection, there's no federal copyright protection. It still doesn't mean there's not a state copyright protection allowed, especially on some of these very early works. And you see that a lot in the music industry with sound recordings. And I'll explore that in more detail in our sound recording discussion. Deposit. Within 3 months of publication, deposit the work, 2 copies. In the Copyright Office, U.S. only. It's 1 copy if it's unpublished, or if it's published outside the U.S., or if it's a collective work. So the question is, should we have formality requirements? That's going to be this week's forum post. What do you think about formalities? Should they be there? Pros, cons. So the next topic this week is duration, and that's going to start in the next video.